Moving on to our other big story of the day today, we're talking about the Nevada legislature, Assembly Bill 200 specifically. Now, it would allow officers to check someone's phone at the scene of a crash to see if the driver was using that phone when the crash happened.
Okay, so think of it like a breathalyzer, really, right? So the bill would allow the use of new technology many are calling a textalyzer. Again, comparing it with the drinking technology. Paul Nelson joins us here in the studio after talking to lawmakers about this issue. Paul, where do they stand?
Well, there's still a lot of questions about it, Kristen. Most lawmakers agree texting and driving is dangerous, and that's why it's illegal in our state. But a lot of people don't know a lot about this new technology, and they have a lot of questions about the right to privacy. Distracted driving is nothing new, and neither are the dangers that go along with it.
I lost my son to a distracted driving, and I learned about this broken system that exists.
It's been illegal for drivers to have a device in hand for 7 years in our state, but many still do it, and the only way to enforce it is if an officer sees it happen. But new technology could allow officers investigating a car crash to test your phone on scene if someone was seriously hurt or killed.
Never leaves the driver's hands, and in roughly 90 seconds, it detects typing and swiping. Just that illegal typing and swiping, and it knows the difference between voice activation and Bluetooth.
Assembly Bill 200 would allow officers to use the so-called textalyzer to see if distracted driving may have played a role in the crash. More than 300 people died on Nevada roads last year, and many people hope this legislation could help reduce that number.
It is a danger to quick check that email or quick check a text. We need to make sure that those phones are away, and I think that this will bring some attention to that issue.
But the bill has mixed reviews. Some say it has good intentions, but that it violates the Fourth Amendment as an unreasonable search and seizure.
The Supreme Court is very clear that a warrant is required in order to access cell phone information, and we think that the bill, as it was written, was missing that component.
The original bill did not require a warrant, and it said a driver that refused the test could lose their license for a year. Both of those were changed, and penalties would not change from existing law. Lawmakers say the bill could require even more fine-tuning.
That's balancing the fact that people are texting and driving, which is dangerous, and on the other hand, the fact that we have a Fourth Amendment right to privacy.
Supporters say the new technology would not have access to private information or photos, but others are skeptical. Some brought up other concerns like simply touching your screen to refresh it, or if a passenger was using the driver's phone. So this bill could see lots more discussion. Of course, we'll be following the legislature closely in the months ahead, so stay tuned to 2 News for continuing coverage from Carson City. Covering the 2019 legislature live in the studio, Paul Nelson, 2 News.
A lot of good